Welcome to Impact Makers Radio, helping you to find jargon-free information before choosing a professional to help solve your problems and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And during this segment of the show, I have divorce attorney Samuel Thomas, who is the partner at Thomas and Fargione Law Group in Athens, Georgia. Now, Samuel, or Sam as his friends like to call him, will be talking to you today about exploring the different types of child custody arrangements. So if you are out there seeking jargon-free information before taking on any form of professional help, you might just want to stop what you're doing, find a quiet spot where you won't be disturbed, and listen in to what Sam has to share with you today. Welcome to the show, Samuel.
Thank you for having me.
So before we jump into the heart of our show today, let's just get the legal stuff out of the way. So it goes without saying that anything you share with us is not any form of legal advice or assistance or therapeutic advice or assistance. It's purely for the purpose of disseminating information. So could you just please expand on that in your own words so we're emphatically clear about what we're trying to achieve today, please, Sam?
Sure. This interview is mainly for informational purposes. I do not typically give it legal advice to anyone that is not a client and or consulting with me. That usually requires some kind of form of engagement letter as well as some kind of form of tender or payment so that there is a contracted attorney-client relationship. Without that, I'm offering this only as information to better help you to prepare in your situation and or seek out your own legal counsel so that you may be better prepared in your case.
Okay, thank you for sharing that, Samuel. So to get things started, please briefly describe your company, the people who you serve, and the kind of situations that they find themselves in when they come to you for your help.
Sure. We are a two-lawyer law firm here in Athens, Georgia. We have a staff of about 8. We help people that are coming in, usually going through the worst times of their lives. Their spouse has walked out on them. They are in the middle of a fight with their fellow co-parent of their minor child. They don't know what's going to happen in the future. They feel like they're completely in the dark. They're looking for some kind of reassurance and or light to get out of this darkness that they find themselves in.
So my next question for you then, Sam, and I'm sure we could spend a whole interview just addressing this question. What's one of the most common misconceptions surrounding your industry?
So usually when I get a father of a child that comes in for a child custody case, I mean, his biggest concern typically is, how often am I going to see my children? Am I ever going to see my kids again? My spouse has ran out and they've taken the kids. Am I going to see my kids again? She says that she's never going to let them see me again. And so that's typically a big misconception that some of these fathers may have in these situations. Without some kind of aggravated circumstance, you're going to see your children. It's a matter of how much and how often. It's not that you're going to see your children any longer. So I get that as a big misconception, typically when a child custody consultation is scheduled on my calendar. That's the first thing I try to, pull them back down into reality. I mean, you may be separated from your former significant other. You may be divorcing, whatever the case may be. You're going to see your children. They're still going to have a co-parenting relationship, like I said, barring some kind of really aggravated circumstances that most people don't find themselves in to start with.
Where do you think that misconception stems from then, Sam?
I think a lot of times, it depends if someone is married. In our jurisdiction, if it's a father of a child, that the two parents were not married, under Georgia law, the father has no rights. And that's one of the things that they often read on, Google searches or whatever, is I have no rights to my kid, so I must not be able to see my kid anymore. That's going to require a different form of a legal action, but it's nonetheless going to get, theoretically, the father some custodial type rights. In the divorce, there's a lot of times of an allegation of an affair. And so the father that would come in and consult with us would be, my wife says that, she caught me cheating. So by me cheating, I'm not going to see my kids. It's kind of a form of punishment. and they really don't get crystal clear answers on, when they do a quick online search. So I think that feeds the misconceptions and how often they're going to see their children going through this legal action.
So always best to speak to an attorney if in any doubt at all.
Absolutely. I mean, even if you choose not to hire the attorney, at least a lot of times they will give you some, at least pointers or some early guidance that can put your mind to rest and then bring you some sense of calmness into this action, even though it's hectic and emotional nonetheless.
So how do people benefit from being aware of the various types of child custody arrangements, which is your topic for today?
So child custody, a lot of people get bogged down into the titles, whether they have joint legal custody, joint physical custody. I mean, to start with, there's two different forms of custody. There's legal and there's physical in most jurisdictions. Legal custody has more to do with legal decision-making powers for the minor children, where they're going to go to school, who they're going to use for their pediatrician, what religion are they going to be brought up in, should they participate in some kind of extracurricular activity. Those types of decisions all have to be handled in the action at hand, whether it be a divorce, a legitimation, or whatever the case may be. They have to have some kind of decision-making process. Usually what we have is two parents are supposed to talk about the minor children's issue. Most times, most parents will agree to whatever the resolution may be. However, that is not always the case. And so when that happens, they have to have a tie-breaking authority. And then it feeds right into, physical custody. And that is what more people fight over than the legal custody portion. And that is who is going to have the child or children when and how often. And so that there's a actual structured schedule of who has the kid when. The different types of arrangements for child custody. A lot of people have gone into a divorce or a child custody action thinking one parent's going to be the every other weekend type parent. And that was pretty much the standard for many years. The courts, at least in our jurisdiction, have started a trend. And I think I'm actually a big fan of it. I think that the courts are now expanding upon that. They're not going straight to Friday to Sunday for a visiting parent as much as they used to. They have expanded those weekends. A lot of times nowadays, they will give the other parent, say, Thursday night after school until Monday morning. They would take the kids back to school, and then that's when the other parent would retrieve the kids. So that weekend that visiting parent would have is not just like 72 hours. It's actually expanded, so it's not quite a 50-50 type arrangement, but it is closer to it. I think many of the judges in our jurisdiction have now recognized that the kids benefit from having both parents in their lives as much as possible. If they can't have mom and father together as a one-unit couple, they need to at least try to mimic that through some kind of form of 50-50. So that is what I'm seeing as a trend now, but not everywhere, but it is growing.
So I certainly subscribe to a more balanced approach to child custody, as you just mentioned there. So I like the sound of that trend. However, if there's a parent listening in right now, and let's say it's the mother, and she's in that situation where there's conflict between her partner and they are going through this divorce separation process, and in her mind, she is absolutely convinced that the more time her child spends with the father, the less good that actually is for the child, and wants to have most of the custody arrangements. And then on the other side, it's more or less the same, right? So you get this two in and fro-in.
Sure.
I'm sure you come across that on a regular basis. Well, if there are a couple who are listening in right now in that situation, what would you say to them?
I would say, if the child is old enough to get into mental health treatment counseling, going through a divorce or any kind of child custody action weighs on not just the parents in the action at hand. That stress gets transferred a lot of times to the minor child. They can sense, they can pick up that mom and dad are stressed out, they're angry, they're upset, they're crying, whatever the case may be. They pick up on that. They have a hard time watching mom or dad cry and deal with these kind of things. So if the child is old enough to participate in the counseling, I always recommend sending the child to a counselor. I'm a true believer that all of us probably could benefit from some form of counseling from time to time at least. But yeah, a lot of times in our jurisdiction especially, we cannot get statements by the child in. So if you have a mom or a dad coming in and saying the least they can see the other parent, the better, that's only going to weigh so much on the judge's mind. The judge is probably going to take it as this parent doesn't like the other parent. So you have to have something that is kind of corroborating that evidence. And that's typically where a child psychologist could come into play. They are the expert here. They can take what the child says, whereas the parent cannot. The parent can't come into a courtroom typically and say, my child says he doesn't want to see his mom. But the child psychologist can say, hey, I've been working with this minor child. They have expressed some really strong anxiety going to mom or dad's house. I think it would be harmful if, this child were to be subjected to some kind of increased visitation with that other parent. And so that gives you the weight for a lot of times for a judge to consider maybe some reduced visitation, or even in the worst case scenario, suspending visitation. So I think that's a big tip, that anybody that wants to maybe limit that visitation exposure to the other parent, they really need to consider some kind of form of expert.
What would you say is an appropriate age for a child to be seeing a psychologist?
I've seen them go as low as around 4. Obviously, the older the child is, the better, because they can express more things. They can articulate things that they've seen at the other parent's house, and that the child psychologist could actually, pick up on and explore that topic a lot more with their patient. The older the better. If they're not young enough, if they're too young, then you're going to have to find some form of an expert opinion. Typically, we recommend what they call a guardian ad litem. It may be called different things in other jurisdictions, but that is typically a child's attorney. And that person is looking out for that child's best interest. They don't care about parent 1 or parent 2. They are strictly there for this child. And they are the ones that are looking out for them and conducting an investigation on behalf of the minor child and what should be the arrangement for a custodial parenting time.
These are such good insights. I'm so glad that you're sharing this with our listeners, Sam. So moving forward, if somebody, you mentioned going online, and there's lots of information which leads to these misconceptions about what the truth is, etc. So if someone goes online and they're looking up information about child custody arrangements, with the array of content that's available, that can be quite intimidating. So in your experience, what are some of the most common fears people have surrounding the topic of child custody arrangements, and what strategies could they use to get past that fear?
A lot of parents will get bogged down, like I said, in those titles, where there's joint physical custody, sole physical custody. The main thing they really need to focus on is who's going to have the kid or kids when. That really kind of a lot of times dictates the titles, because that's one of the most confusing things, is what is the difference between sole legal and joint physical and joint legal. They don't understand that those are all just terms that lawyers can throw around. We know what it means. The parents that are typically researching this online, that goes right over their head. They don't understand exactly what does that mean, what does that imply, what does that mean in reality when I'm dealing with my former spouse or former significant other or just the father of my child or whatever. They typically don't understand all of the terminology. So to get past that fear, try to at least shop around, find an attorney that will give you a consultation, talk about your specific situation, reduce the fears, reduce everything else to the point where they can understand what are they entering into, what are they going to want when it comes to court.
When it comes to exploring the different types of child custody arrangements, what are 1 or 2 unknown pitfalls people should avoid, and how can they avoid that?
So one of the things I see often, most times in divorce situations, is there are divorcing parents. They have minor children together. They know they've got to share these kids in some form or fashion. And then one of the parents decides to start dating. That is I call it a pot stir. So they all of a sudden get a new boyfriend, girlfriend, whatever the case may be. And then the other parent, is fighting this tooth and nail. They do not want the new lover around their kids. They don't believe this person is, valuable or is going to be a good influence on the kid. And so this causes a lot of times the case to get back into the courtroom. My advice in that respect to try to avoid that pitfall is let the case get over with before you start dating. If this person, or if you're going to date, at least don't bring this person around the kids too soon. Have that discussion with the other side if you're able to have a civil conversation. But typically, the one way I try to avoid this pitfall is we put it in the paperwork that, neither parent shall introduce the significant other or have them as an overnight guest with the kids present until that relationship is something like 6 months old. So that we're not, if you have like a parent that is, constantly dating someone and dropping them and picking up a new significant other, that we're not, exposing the kids to too many different significant others on behalf of one parent. So that is a big no-no. Another pitfall that I would see is a lot of times parents, and this depends on where you are and what jurisdiction you are. In my state of Georgia, marijuana is not legal. Even though, there are 19 states across the United States that have legalized recreational marijuana, Georgia is not yet one of them. We have medical marijuana, and they have this misconception or a pitfall of it's just marijuana. It's not going to hurt anybody, yada, yada. And in Georgia, that is not the case. We don't look at marijuana as the same as, say, alcohol. So that's a big red flag that we see a lot of times. And I get a lot of parents coming in here saying, my kid's father, my kid's mother is constantly using marijuana. He can't watch the kids. He can't watch the kids. He can't even drive. I mean, if they got sick and need to go to the hospital or doctor, he's stoned.
If that's proven to be true, what kind of consequences could that have for either one of the parents?
I mean, so one thing that I think a lot of judges do in that regard is they will start drug testing the parents. And you have to have, it maybe go to a supervised visitation schedule here until you can prove that you are no longer using it. We typically use a hair follicle drug screen. We don't use the urinalysis. We use a hair follicle because it goes back further, and we start to see levels of how much is in their system. And as long as, they keep taking these hair follicle testing and the levels are coming down, that signifies that that parent is no longer using, and it's getting out of their hair and their fingernails and everything else. And once they prove that they are not using, then they can start to resume a semi-normal visitation schedule with the kids.
Really interesting. It's fascinating. Any other pitfalls?
I mean, alcohol is always one of them. So what I typically put into my parenting plan for two parents is, and I don't want to be, we don't try to micromanage a parent's life. So if the father likes a beer with his dinner, or, mom likes a glass of wine, or whatever the case may be, we're not going to penalize that. We're just saying we do not abuse alcohol or get intoxicated while the kids are present. But some people, want to take it a step further, and they don't want any alcohol while the kids are present. And I understand that too. So I try to typically judge it case by case in that regard for alcohol, because it's legal everywhere compared to marijuana.
So let's just switch gears a little bit then, Samuel, and talk a little bit about the courts. What factors do the courts typically consider when determining the most suitable custody arrangement for a child in a divorce case?
So in Georgia, I believe we have 14 factors the judge has to consider in the best interest of the minor children. And typically they look at everything. And if one of them, of course, is like substance abuse problems by a parent. Another one is a domestic violence history between these two parents. Those are always applicable factors. Another one is the parent's knowledge of the day-to-day routine of the child. So a lot of times we have a mom come in and she's been the one that's been caretaking for the child the whole time. She knows everything. She knows the kid's teacher. She knows the kid's routine, what he or she likes, their favorite food, their best friends, etc. And typically, it's not always the case, but a lot of times the father will not know a lot of those things. They know what their kid likes, like he's a big baseball fan or whatever, but he couldn't tell you who their teachers are. That's a big red flag a lot of times for judges. And so if you're going through a custody case, you're going to definitely want to know the ins and outs of your kid's life. You need to just talk to them, and learn about them as much as you possibly can learn. Because I've had too many clients that get grilled on cross-examination in a courtroom, and they don't know their kid's teacher. That's how much do you really know your kid that you're wanting custody for? And that's a hard one to answer. But if you know your kid 100%, you've interviewed them and all the type of topics that you could come across for a child's life, then you look a lot better in the courtroom.
So sticking with the topic of the courts, how do they handle situations where, let's say, parents live in different states or even countries, and what impact does this have on the custody arrangement?
Absolutely. So those are some of the hardest cases for judges. It's easy when mom and dad live down the street or, 5 miles apart. It's a completely different thing when I've had a case where the mom lived here in Georgia, but the dad was moving to the state of Oregon. Well, that's across the country, 3,000 miles or whatever it is. They're not going to see each other very often. So the judge is forced, and then I mean forced, to deal with possible school breaks as the basis for the other parent. So if, the child is going to be out of school for the winter break starting, mid-December until early January, they like to capitalize on that. They like to capitalize on the summer breaks for the minor child. They like to have spring breaks. But typically, if it's like a 3-day weekend, for example, Martin Luther King Day weekend in January, how realistic is it to send that parent across the country to see your kid for one weekend and then fly back? Now, that's really hard. They will give the parent typically that is going to be the visiting parent, they will give them the benefit of the doubt and say, look, if you want to see your child any 3-day weekend, all you have to do is give the other parent X days notice or X hours notice that you're going to fly out to where they are, and you can have a visitation, and we're not going to stop you. That's going to be part of my order, but that's the reality when you're talking about a long distance. And it gets even worse when you're talking about over country lines, borders. I have had clients that, one's going to live in Georgia and the other one's in Poland. That's a different kind of arrangement. Once again, you're still capitalizing on the long summer breaks and everything else, but one parent's going to not see their child for most of the year. And that's one of the toughest cases when the two parents are fighting out custody, because no matter what the judge does in that situation, one parent's going to suffer.
So, Sam, if you would allow me to just, again, switch gears and talk a little bit about you and your profession, can you share 2 or 3 perceived obstacles that may prevent someone who is in need of a professional like yourself from seeking help?
Sure. I think the biggest one, obviously, is how much is it going to cost?
Mm-hmm.
Because you read online, if you do a quick Google search or whatever, you'll see how much does a child custody attorney cost. And that varies by jurisdiction, but they'll try to give you the average answer. And I think I saw it last time on Google was something like $20,000 to $25,000 to start. That's not always the case, but I mean, that is a huge red flag for a lot of people. They cannot afford that. So I always say that the cost of an attorney is one of the biggest obstacles people face. They don't know how much this is going to cost me. Is it worth it? Can I just represent myself? And I mean, my advice to anyone to try to avoid that obstacle is obviously shop around, find one that you're comfortable with, find one that's comfortable with your budget. And then one of the things we do at our office, we typically offer some kind of financing arrangement. We are not the ones that actually do the financing. We have an independent contractor or vendor that helps with the financing process so that you can finance your litigation. And it's more reasonable as far as your budget goes. If I charge you X dollars, but the finance company is only going to charge you a certain amount per month that's within your budget, then it becomes available to you. Whereas before, it was just a large sum of money that you see that you owe this attorney. And so that always prevents people from maybe even taking up the case in general. That maybe they may think it's not worth it. I can't spend that much money. And so that prevents them getting the legal help they need.
Listening to you, Sam, it's obvious to me that you're an expert in your field. So if you could just share, when it comes to the various types of child custody arrangements, that some of them you've touched on today, and there are obviously a lot more, and obviously keeping your client's confidentiality in mind, could you share just, let's say, 1 or 2 examples of how you've been able to help someone to succeed in gaining the results they were looking for when they initially reached out to you for your help?
Sure. So, I mean, I've had plenty of clients that have come in and they may have been through the divorce process before and they didn't seek custody at the time. They thought my child's mom or dad is a good parent and I'm not in a good place right now for whatever reason. Maybe they had a substance abuse history or whatever the case may be. And they didn't fight custody at the divorce time. But now they're coming in for a modification of child custody because the person that they thought their significant other at the time, their spouse at the time, was a good parent, now may not be such a good parent. They may be screwing up things like getting the kid to school late on time or getting the kid to school late, and they're racked up a lot of tardies or absences. And so they are now not in the best place to care for this child. And so we have done that before where we've gotten somebody that didn't fight for custody to start with, but now has custody thanks to our representation and put the kids in their physical care and custody. That's something we're always very proud of because we've helped that person a lot, even helped that child be put into a more stable household than they were with the other parent that may have started off with custody.
As a reminder, my guest is divorce attorney Samuel Thomas, and Samuel has been addressing the topic of exploring the different types of child custody arrangements. Now then, Samuel, you've shared some great insights so far, so let's just talk a little bit about you. tell us a little bit about your backstory. What was it that led you or even inspired you to become and do what you do today?
Sure. So when I was about maybe 11 or 12 years old, I remember my sister going through her own divorce. And it was they didn't have any assets or really anything to fight over except my nephew, or the only thing we'll call it a thing in the divorce itself that was worthy of fighting over, because all they had was debt, to be honest, other than him. And so I watched from a firsthand account of the divorce from my sister, who was living in my mom and dad's house with I when I was a kid. And I watched the lawyers on both sides, and some of the solutions they were proposing were just, I look back on them even as an attorney, and I go, what the heck were they thinking? That's not a resolution. One of them was suggesting that the father of my nephew should come over and basically spend the night, and they had been separated for months. And it was just like, this makes no sense. This makes no logic. And even today, I'm looking back on that was never a good idea. So I thought there has to be a better way of doing child custody. And I kind of had an inkling toward family law since then. And then when I went to college, of course, law school, I knew I was probably going to go to family law just because it was something that interested me. And so ever since then, I've tried to keep that in mind. We are creative in solutions for child custody and divorces, but I mean, we also make sure that they work, or try to make sure they work, or logical at least, not trying something outlandish that just it's going to stir up the pot, it's going to create more tension. That doesn't make any sense. We want to try to put families and parents on the track to a kind of a peaceful arrangement, and that was not one of them.
So when you're able to put your clients back on the right track, what do you get from that then, Samuel? How does that make you feel?
I like it a lot when I get somebody put into a peaceful mindset. And I've been complimented a few times by different clients talking about how a lot of times will come in here and they're emotional, and then when they leave, they always feel better. So we stress that we're not so much the attorneys, we're also the counselor. Because we feel like in family law, you're more of a counselor than you are the attorney. May not be the same way in like business litigation or something along those lines. Family law is more counseling than it is lawyering. So it's always a kind of yeah.
Go ahead. I was just going to say, my wife's out and about right at the moment, Sam, but you sound so good. I think when she comes home, I'm going to file for divorce just so you can be my attorney.
Sounds great.
Sounds like a plan. Just so I can hang out with you for a while. But on a serious note, if there is somebody out there and they're looking to evaluate a professional in your field, what are some of the things they should be looking out for?
I would, first off, I mean, just on a personal note, they should always look at this, just somebody that I can tell some of my the deepest, darkest secrets to. Because here's the thing, if your spouse knows about the secrets that you told him or her about, you're going to need to tell the same secret to your lawyer, because almost definitely those secrets are going to become issues in the case. If you've had a prior problem with drugs or alcohol, that's coming out. Go ahead and tell your lawyer that. So you have to be, first off, make sure that this is someone I can tell my stuff to. If you don't click in that first meeting, you're probably not going to click 6 weeks from now. And there's nothing wrong with that. If you meet with a lawyer and you don't feel like you are a good fit, go somewhere else. Try to find another person, and find the person that you're okay with speaking to. And that's a big thing to start with, because you're going to have to trust this person, that they're going to put your needs above all else and represent you, so that you need to be able to have a good relationship with them. Another thing I always tell the clients to look for in general is make sure this person has experience. I know back when I started practicing law, it was a downturn of the economy. Well, we had a lot of real estate attorneys jump into family law, because family law typically stays busy, even good times and bad. And so these people have never really tried a divorce or a child custody case. Do they really even know what they're talking about? So ask them how many family law cases they've tried. They should be able to tell you that. And then I always have people say, how many cases have you won? What's your win-loss rate? Family law is not one of those that's so easy to say, I have 6 wins, 4 losses. No, it's not like that, because family law is more about compromising or splitting down the middle somewhere, either by agreement or by judge's order. So it's not easy to say, I won that case or I lost that case. A lot of times you will get some of that as a win, some of that as a loss. But you need to know how many cases they've tried in family law. I mean, for example, I've been doing family law over 10 years roughly now, and I've probably tried close to 2,000 divorces or child custody cases in family law in general. So, I mean, I've been around the block a couple times on family law, but, I'm not going to try to say I do the same thing for a will or a business litigation or anything along those lines. I don't have experience in this. So I don't try to, form myself as an expert in those kind of practice areas. Whereas family law, I've been around a few times. I've seen a few things, and I know what judges typically like, what they don't like. And so you need to know that your attorney has some kind of experience there so that they can help you navigate the complex child custody or divorce situation or whatever you find yourself in.
So with 2,000 plus cases under your belt then, Samuel, anyone listening in right now just may think, something, this is the guy I need to just pick up the phone and give a call. So if that is the case, what's the best way for them to get in touch with you, one? And two, even more importantly, when they do take that step, what will actually happen? What's your process? I mean, people want to know before they pick up the phone that there's no risk. You're not going to try and, drag them to the back of your office and steal all the money out of their purse, hit them over the head with a Fred Flintstone club. Please share. How do they get in touch with you? What's your process? Go ahead.
My office telephone number is 706-546-0999. They can either call and set up a risk-free telephone consultation. Tell me about their situation. If I can help them, I will, give them options, give them prices, give them everything they need. And then they can make the decision on their own. Should this be the person that wants to be representing me? They can also email me at sam@T, as in my last name, Thomas, F Law Group, tflawgroup.com. And they can shoot me an email, same thing. They can say, I'm facing, my name is such and such. Here's what I'm facing. Is this something you could help me with, or do I need to go somewhere else? And I'll give the straight answer, like, you're in California, I'm in Georgia, I can't help you. I could recommend maybe a California attorney you may want to try calling and see if they can help you. So there's no risk for them to reach out to me. And if it's something I can't help them with, maybe I know somebody in their state or their area that they really need help with. Maybe I know someone I can always refer them to. I have lawyer friends from all over the country.
Right, so you can help them with that whole 360-degree approach to supporting someone. Perfect. Okay, ladies and gentlemen, that's all we have time for today. You have been listening to divorce attorney Samuel Thomas. Thank you so much for sharing so generously with us today, Sam. You certainly have demonstrated that you are a true educator and advocate for the success of your clients, and we truly appreciate your time, your insights, and your dedication to helping others. So thank you so much, Sam.
Thank you for having me.
You are so welcome. And I'd just like to take a moment to say a big thank you to you. Yes, our listener tuning in right now. Without you, we wouldn't have anybody to speak to, and Sam and I would be sat here twiddling our little thumbs. So thank you for taking the time out of your hectic schedule and for joining us in this enlightening and informative discussion with one of the foremost divorce attorneys in Athens, Georgia today. Again, his name is Samuel Thomas. Make sure to check him out, because if there's one thing I'm sure of after listening to Samuel today, is that you are going to be in good hands and a safe place to get started. So that's it once more. I'm Stewart Andrew Alexander, and we'll be back shortly with some more leading divorce professionals in this, our series, Let's Talk Divorce Conversations. So until then, take care. Have a great day, and always remember this: conversations with care save your children's despair. Now you're getting divorced. I know, it's not fair. No matter the pain and the troubles to bear, the children come first, and for them we must care. When you feel your blood boiling and your voice you must air, remember, the children are listening, and for them it's not fair. Bye for now, ladies and gentlemen. Take care, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present, and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.